Welcome everyone for the first morning of spring. That is antitrust spring of the ABA antitrust section. I'm the vice chair and thrilled to see you all here, also a partner at Milbank in New York. So it's been pretty quiet around the antitrust division recently. Not much going on. What are you guys up to, hey? Well, this morning we're going to find out. These people are dedicated, they work longer hours than we do, and they have a mission. And we're going to hear what that mission is today. So I'm absolutely delighted to introduce a full panel of DAGs here, starting off with Doha Mekki, who is the principal DAG. And then we have to my far right here, Richard Powers, who I think many of you have seen on this podium a number of times. You may not have seen so many times before, but let me tell you, you will be seeing many times in future, maybe in a litigation involving your clients. Carol Sipperly to my immediate left. And Heschel, did we get you a card, or are you still Mystery X?
Alas, I can no longer be the real Slim Shady over here.
But we aspire to that. So Heschel Doshi makes our full complement here. Well, we always start out these programs with a personnel update. We've all, I think, seen that Congress has decided in its infinite wisdom to give you guys literally billions of dollars to up the ante on antitrust enforcement. Tell us, Doha, who is going to be in charge of this? Who are the new faces, and what can we expect from them?
Let me say in the first instance that Congress still hasn't given us quite enough, so I would just note that for the record. So first, let me say what a pleasure it is to be here in person for what is always a really compelling and interesting set of programs, and so we thank the ABA for having us. Before I talk about personnel moves within the antitrust division, I want to take an opportunity to recognize the heroic work of the antitrust division during what I will say was an unusually long transition. And in particular, I want to thank my colleague, Richard Powers, who for 10 months served as the acting AAG. And through his institutional leadership and thought leadership, when AAG Cantor and I stepped into our roles late last year, we inherited an institution that was firing on all cylinders. And he was, of course, supported by a number of career leaders, including Kathy O'Neill, Jeff Wilder, Marvin Price, and Jimmy Attridge, who is our acting chief of staff, who did a fantastic job stewarding the agency while political leadership arrived. And last but certainly not least, I want to thank our career staff, our beloved career staff, who work so hard every day and do the work of antitrust enforcement that the public deserves. And so I really appreciate the opportunity to highlight new members of our team and promotions over the last year. And that's because we've brought in and promoted a number of really talented, energetic people to help advance AAG Cantor's ambitious agenda. If you know Jonathan Cantor, you know that he is very fond of saying that personnel is policy, and I think his policy is reflected in his personnel choices. And so in the front office, we are joined by two folks who are on the stage. We have not one, but two litigation DAGs. Carol Sipperly, who is, in addition to being a first-rate prosecutor, a wonderful person, and Heschel Doshi, who joins us from the Denver U.S. Attorney's Office, and she is a marvelous prosecutor with deep civil and criminal experience and really trial experience that the division will benefit from. At the director level, I want to announce that Dave Lawrence was elevated to the first ever policy director, and that means that he oversees the international competition policy and advocacy and appellate sections. Earlier this week, we made an announcement that Ryan Danks, who had been the chief of the Washington Criminal 1 section, will serve as acting director of civil enforcement. Brian Young, who's an exceptional prosecutor, who joined us from the criminal division last summer, is serving as one of our co-directors of criminal litigation and senior counsel to the AAG. In addition, he will be joined by Kevin Hart, who had been an assistant chief in the Washington Criminal 1 section and those two will serve as the acting co-directors of criminal litigation. We're also joined by a number of talented people as counsel in the front office. And so first up is Sarah Allen, who joins us from the Virginia AG's office and who had served as the NAG antitrust, leader of the NAG antitrust task force, and she will head up our state relations efforts. Eric Posner, who really needs no introduction, joins us from the University of Chicago Law School, and he will serve as counsel alongside Sarah. And he will be focusing on our labor competition efforts, which, as many of you know, is near and dear to my heart. Perry Applebaum joins us as senior counsel. He had previously served as chief counsel and staff director for the House Judiciary Committee. Patty Brink, who's a perennial favorite at the Antitrust Division, returned from a year-long detail to the Office of the Associate Attorney General, and she will serve as senior counsel for international and intergovernmental engagement. John Elias is back in the front office as Deputy Chief of Staff and counsel to the AAG. Andrew Mast also joined the counsel ranks from the San Francisco office. Tim Longman stepped in as counsel. He had previously been in the international section. And finally, Becca Ryan became counsel to the criminal directors. You might think I'm done, but I'm actually not done yet. Tricia Corcoran graciously agreed to come to the front office during that transition that I just described, and she served as acting chief of civil operations. She will be transitioning back to the TEA section, which, as many of you know, is gearing up for 2 trials over the next 5 months. There's the U.S. Sugar Imperial merger litigation that starts in a couple of weeks, and in September, they will be focusing on the lawsuit against American Airlines and JetBlue. We also have 2 fantastic Rill Fellows, Spencer Smith and Jared Bond, who joined the front office in October. And we also have a number of leadership additions in the civil, criminal, and policy sections. Yvette Tarlov is the new chief of the Media, Entertainment, and Communications section. Karina Lubell is now the chief of the division's Competition Policy and Advocacy section. And with Ryan Danks helping the civil program, Emma Burnham has agreed to lead the Washington Criminal 1 section. We also have a number of new assistant chiefs. Jenny Cho has been selected as assistant chief in the Defense, Industrials, and Aerospace section. Corey Brader-Leuchten is an assistant chief in the Media, Entertainment, and Communications section. Megan Belshaw is now assistant chief in the Financial Services, FinTech, and Banking section. And since this fall, Carolyn Lays has been acting as an assistant chief in the Transportation, Energy, and Agriculture section. Amy Fitzpatrick, who had for a long time helped lead civil operations, stepped into a new role as Deputy Chief Legal Advisor, focusing on the civil portfolio. And Tracy Fisher has replaced Nina Hale as the division's ethics officer.
Well, that's a long list, and we're going to be seeing plenty more of all of them, so thanks for highlighting all of these changes this morning. So one of the new people, maybe a little newer to us in the antitrust bar, but certainly not new to enforcement against financial institutions, supervision of AUSAs, and other multi-billion-dollar investigations and settlements, is Hetal Doshi on my far left here. So Hetal, I know you didn't grow up reading ALD to get to sleep at night, but maybe that wasn't a requirement for this job. I imagine it wasn't. Tell us how your enforcement experience and background, including in cool things like cryptocurrency, which, you know, as a boomer and a Karen, I'm still trying to get to understand. Tell us, how will that bring your enforcement to the next level at the Antitrust Division?
And then tell us how we get our crypto back. Hi, everyone. Thank you for that warm welcome, Fiona. As Fiona mentioned, I am new, as evidenced by this. I think this is maybe my 12th or 13th day on the job, so I know just enough to be dangerous here today. You know, I really want to thank all of you for being here. I've reconnected with friends, old and new, and I also am really grateful for the extremely warm welcome that I've received from the Antitrust Division and the talented staff and counsel there. It's been a remarkable transition, and I've really been able to jump right in over the last 13 days. So, you know, I think it's in the course of my career, particularly in public service, I've spent a lot of time building from like an nascent investigatory stage, complex investigations about complex financial products or perhaps sophisticated corruption schemes, for example. And the through line through all of that that's been really relevant as I'm scaling up in this new role is thinking about this always through the lens of, what can we do to ensure market integrity? And beyond that, as a buzzword, really diving into that, meaning how do we make sure that our system works such that people can recognize and achieve economic self-determination? And so while global financial crisis or cryptocurrency, which I'm going to talk about here, may seem like higher scale, higher order cases and investigations, the fundamental fact is that I think about cases and building cases in terms of how to explain it to a layperson. And, given that, I think that the fact that I haven't spent, I spend my time reading such wonderful publications like People Magazine to go to bed instead of the ALD, as it sounds like maybe I should. I think that there's a real opportunity here in the fact that I'm not as steeped in the antitrust bar in the way that all of you are, perhaps, in the sense that perhaps I have an opportunity to step into the shoes of a lot of our triers of fact, whether they're judges or juries, in thinking about first principles that animate the idea of what competition is really meant to do. What I mean when I say that is I think that so much of what our trial practice should be about, particularly whether it's in front of a judge or in front of a jury, really needs to start from a place of educating our triers of fact about what the relevant law and principles are, and that's something that very much translates when you think about exotic financial instruments and explaining those to a jury, right? But in addition to that, I think that there is a way to start to think about how do we take the language of antitrust, market allocation, price fixing, bid rigging, which seems so intuitive to all of us perhaps in this room, and really make it part of the experience, make it much more accessible to those triers of fact that will be deciding these issues, because there is a fundamental appeal. People understand, if they may not be able to explain what market allocation is, they know a cheat or an unfair system when they see it. They understand what it means to be able to go out and have a fair shake in the labor market or in the competitive market in terms of the goods and services they buy. And so this is a natural extension of the work that I've done, in particular in the financial industry, in terms of vindicating those issues. The other thing that's interesting is that while the burgeoning area of cryptocurrency fraud and crypto just investigations in general seems, again, like it's highly technical, to Carol's point, like how do we get our money back, right? There's that old adage that there's nothing new under the sun, and I think that what's really exciting about that building that practice, and that's highly relevant here, as you might hear later today about, is that we have a lot of really great tools in the federal statutes in our toolkit. And so while the money laundering statute, for example, perhaps did not contemplate a world in which wallets didn't exist in our purses or bags, but instead on our phones, that doesn't mean that we can't reimagine and creatively use existing laws to deal with our new digital landscape. And so certainly that's going to be top of mind for me as I think about the trial teams that I'll be working with in terms of saying, how do we use all of these old tools in a new way to confront the reality that we have in today's market? So, like I said, I'm really excited to be here. I think that this next step and this next chapter in terms of learning to be an expert in the same way that you are will be exciting, and I look forward to seeing a lot of you in the courtroom.
That's great. We look forward to seeing you there too. So Carol, I know you started out life as an AUSA in New York, which for those...
100 years ago.
Well, I think I was there with you, but I wasn't an AUSA, and I can tell you that it's a very, very difficult job to get. It's highly coveted, and one of the things that it does is it gives you incredible trial experience. I think you first chaired or co-led over 30 trials, including of notorious people like John Gotti Jr. and Darryl Strawberry. I'm really glad that...
Gotti, the son.
Yes. I'm really glad that we're elevated to that status. We're super cool now, us antitrust people. One of the things that I think is still going to be a challenge, Carol, is getting judges on board with the new antitrust agenda. I mean, we've seen, in recent times, and I'm not going to mention animal names, but, folks really need to understand on the bench that you are forces for good and that you're, trying to bring the law to a modern state. What are your thoughts on how to best get judges in with the program?
So, I probably have been thinking about that for probably 10 years when it comes to white-collar enforcement generally, especially when it was our financial markets and it was complicated matters. But I actually, when I transitioned to antitrust, sorry, not that you want this louder, trust me. You're better off not hearing me. That's usually my best setting. I realized just how compelling enforcement is. Like, when I got here, I was like, oh my God, the markets that we're protecting really matter. Like, I haven't had the joy of, like, really enforcing conduct that really brings harm, such widespread harm. And when I got to antitrust, I didn't appreciate that. I just thought, all right, I've been working with antitrust people, time for action to move over. So, someone like me, you got to find new enthusiasms. I do feel like, these crimes really, and the civil enforcement, it really matters. And I do think it matters to make sure the judge understands that. And one of the ways that we're trying to do that is to, oh my God, this is too loud, have the judge see it as, a conspiracy. What they're doing is they're conspiring, they're cheating. And I do think the judges are coming to understand what this enforcement's all about. And I will tell you, and I know, we've been having experiences in white-collar enforcement for years when it comes to juries' understanding and judges' understanding, but I do think we're making progress. And that's truly my goal, is to take the talented bunch of people at antitrust. And I will tell you, and I say it all the time, I'm just surprised how much I love the people at antitrust and want to work with them. I want to get them in a position where they are empowered to make the most compelling case when it comes to the judge understanding the importance of this enforcement effort. And, it's not an easy job, but I know every single person can do it, and that's what we're doing. We're arming them to do that.
And I think we're going to talk a little bit later about how you're arming other agencies also to be your litigation allies in this effort. But before we turn to that, Richard, there are just a couple of small announcements this week having to do with your leniency program and your frequently asked questions. Tell us, why did you feel you needed to make these changes? What were the gaps that you feel that you needed to fill? What is it that you want everyone in this room to understand at a macro level about the reasons for the changes and the incentives, sticks and carrots that you're putting in there?
Sure. First, let me just say good morning. It's good to see everyone. And I want to respond to something Doha said. I will tell everyone that it was one of the great privileges and honors of my life to serve as the acting AG last year and to work with all of the talented prosecutors, paralegals, support staff across the antitrust division. It was just truly, and it is truly an impressive team. And so it was a great honor for me to just work with everyone for that year. And I just couldn't be more proud of the work they did and how hard they worked and continue to work because they, as Fiona said, they believe in the mission. It's also a privilege for me to share the stage with my colleagues who are mentors and friends and some of the best prosecutors and lawyers I've ever had the privilege to work with. So let me get that out of the way. But to your question, yeah, there were some changes this week. On Monday we announced a number of policy and practice changes, all of which are reflected in an updated chapter of the Justice Manual. That document is publicly available on the Department of Justice website, and I encourage everyone, especially folks in this room, to take a look and to read through it all. And first off, I want to note that the decision to centralize all of our key policies in one location was a deliberate choice and was itself part of a systematic project over the past year to improve access to justice. On the substantive changes, though, the ones I expect of the greatest interest to the bar and business community are the updates to the leniency policy and FAQ, so I'll start there. So again, the changes aren't just to the leniency policy, there are other changes, so I would encourage everyone to read through the Justice Manual so you can see what those are. So a theme that I've mentioned time and again is the importance of routinely re-examining our policies and practices to make sure they're up to the task, both substantively in terms of meeting our enforcement objectives, and when it comes to transparency and accessibility. These updates are the result of a year-long process, internal process, incorporating the experiences and learnings from across the division's criminal enforcement program. And as a result of that process, on Monday, we announced changes to our leniency policy, the first since 1993, along with substantial updates to the FAQs. They are important updates, some substantive, some clarifying, some stylistic to make the policy easier to understand. But they are fundamentally incremental updates to a policy that, at its core, remains the same. One policy change I want to highlight is that we now require corporate applicants to promptly self-report to us when they discover the crime. So up until now, the policy had been prompt and effective termination. But in our experience investigating and prosecuting cartels in the past decades, we've learned that prompt reporting rather than termination is the key. And that gives the division the best chance to gather evidence through consensual recordings and other affirmative investigative techniques. It also reinforces the prisoner's dilemma that leniency sets up and should provide yet another reason for companies to invest in compliance programs that will stop the violations before they start, or at least allow them to win the leniency race. In terms of what prompt means, please look at the FAQs, which provide guidance on this. But this is a straightforward, common sense requirement with language that tracks the previous requirement of prompt and effective termination. Another key change we've made to the policy relates directly to compliance. To qualify for leniency, a company has always had to pay restitution to its victims. Now, it's also required to improve its compliance program and undertake any additional remedial measures that may be necessary. And what this could mean is spelled out in some detail in the revised FAQs. And we also, as you can tell, made some substantial updates to the leniency FAQs, which were last updated in 2017. We added nearly 50 new FAQs and made sure they're all as easy to understand as possible, and that they address all the questions that applicants and their counsel might have. So taking a close look at the FAQs, we saw that some things needed to be updated to reflect our current practices. And we also thought we could do better to minimize the number of unknowns for potential applicants, especially for those whose counsel aren't as familiar with our program, which is something we're seeing more and more of these days. So for one example, the revised FAQs outline the division's views on how ACPARA intersects with leniency. This provides clarity to prospective applicants on how the division interprets ACPARA and what positions they can anticipate that we will take. We've also provided additional insight on how we exercise our discretion to cover employees of a Type B leniency applicant and clarified the distinction between Type A and Type B. And the bottom line is that for Type A, coverage for all current employees who cooperate with the investigation is guaranteed. In Type B, coverage is not guaranteed, and individuals will be assessed on an individualized basis. If their cooperation can't otherwise be obtained and is necessary to the public interest, we will cover them. If that's not the case, coverage isn't assured. That's why it's in a company's interest and the interest of the executives to invest in compliance and self-report any potential violations as quickly as possible. And that's why it's in an employee's interest to cooperate with us immediately and fully. And I should also note that this is not new. The distinction between Type A and B, individual coverage, has been the policy since 1993. And I recognize that we created some confusion about this through our own prior statements. So let me make this as clear as possible. We don't make or change policy via speech. We won't read out parts of the leniency policy by suggesting on these stages that certain criteria don't actually matter or that the criteria don't apply as written. If we aren't going to consider a requirement, then we will eliminate the requirement, not issue a FAQ that writes it out of existence or give a speech muddying the waters. Otherwise, we fail our own standard of transparency. And when it comes to transparency, we want the FAQs overall to be useful and practical, so we see this as a living document. When new questions and issues arise, we intend to update the FAQs, and that will likely be more frequently than it has been in the past to ensure that they reflect division practices and address the real-world applications of the policy. So let me close with a few thoughts on our process. The policy hasn't changed since the 1990s, and we last revised the FAQs in 2017. Over the years, the division has engaged with the bar and business community extensively in a number of settings, including, and most importantly, when they are before us as leniency applicants. In our experience, improving our practices based on the practicalities of actual casework is far better than hypotheticals. And we have also, of course, gotten extensive feedback from the cartel bar during events like these. We gave that input appropriate consideration when updating the policy and FAQs. But there were also other considerations, like the broader legal and business community that may not be as familiar with the intricacies of leniency. And I'll also note that in updating the policy itself, we thought carefully about the interests of victims of these crimes and the American taxpayers that we represent. And I think it's important to remember that our foremost goal is to ensure that leniency is helping us to hold wrongdoers accountable.
Thanks, Richard. Well, I hear from you a real emphasis on cooperation, but timely reporting and cooperation. Is this a result of your feeling or experience that leniency has languished a little bit recently, and you really want to encourage folks and reinforce that, you know, there is a winner takes all, but then there is maybe a second winner that takes a bit more in coming in second, third, fourth?
Yeah, well, the Antitrust Division has always encouraged timely cooperation, and the leniency program and the paradigm that we employ incentivizes that, right? Be the first to self-report, meet the requirements, and you get the significant benefits. And one of those requirements is obviously now timely, thorough, complete cooperation. So that's always been an expectation, and it's important for us to be able to move our investigations efficiently and aggressively to get the full value of that cooperation. So it's something you always hear us coming back to time and again, which is the emphasis on that cooperation. And the reality is, the longer a company waits to come in, the greater the risk that cooperation won't be valuable, right? I mean, if you win the race for leniency in a type A setting, the benefits are guaranteed and significant for the individuals as well as the company. If it's a Part B situation, a Type B situation, the company still, and the company qualifies, it'll still receive the benefits, but with respect to the executives, you know, there's less guarantees there. But the one thing that will guarantee the best outcome in that setting is moving quickly, being quick to self-report, and cooperating thoroughly with our investigation. And then it goes down the line so that if you're the last company or towards the end, your cooperation likely will be of limited value in that particular conspiracy. So time is of the essence. You've heard us say that before. It continues to be the case. And we think that the changes we announced this week further underscore and advance that point. But I don't know, Carol or Hedl, if you have any thoughts on this too.
Yeah, I do, and I want to also hear from Carol, because I'm sure she's going to have some colorful stories on
I've
this
also
front.
been writing notes like, about reacting to some of the things you said. Nothing's
So, just thinking about cooperation broadly, this is, something that both in Carol and my experience as AUSAs, and continuing in these new roles, we have a lot of experience with, just broadly speaking. I think about cooperation really from the perspective of an opportunity cost, and that is, the extremely talented lawyers and staff, counsel, and whatnot at the Antitrust Division, along with our law enforcement partners. We are going to unravel the puzzle or unravel the mystery and figure it out, and we'll get to the answer. But what can you do as a cooperator to expedite that process such that we don't have to go through all of those steps necessarily on our own, that you can assist us with that so that we can also then work on something else. So what that meaningfully and functionally means in practice, as Richard just said, is to come in early, certainly, I think that's right. But something that's really important to me in looking at cooperation is I want to see the original materials. And what I mean by that is I want access to the witnesses themselves. I want access to the documents in a very fulsome way from the very beginning. And so while, many years ago, being on the other side of this, I understand the desire to put together the really, helpful PowerPoint presentation that talks about the perspective of the company or the individual or whatever. That's great, and we encourage that. But to me, and I don't want to speak for Carol here, but I'm inclined to think she agrees with that, let's get to the unfiltered materials right away, and then we can have that PowerPoint presentation and have additional conversations. The other thing is, I don't think cooperation is coextensive with just, laying down arms and completely capitulating to whatever it is that the enforcer is necessarily saying. It's quite the opposite to me. I think that cooperation contemplates a world in which if there is a genuine live issue that you want to engage with the government on, raise that issue, bring it up early, let's talk about it. So, a world in which cooperation just means that you give us all of your documents, you say mea culpa, and then we move on is not really what I envision. I just think that the issue selection on those genuine live issues is super important, both for your, just from a time perspective, but also from a credibility perspective. If everything is the house is on fire and your case is terrible, eventually you're not going to have as much credibility making those arguments in the cooperation posture. I know that Carol is probably likely to have a lot more concrete suggestions on this as well. Carol?
I don't know about concrete, but I certainly have suggestions. So when I got to work with antitrust, this is even before I moved over, I learned about the leniency program, and I was like, oh, this just sounds like cooperation, except that in the end, it's a slightly different end game, right? And so as I saw the cooperation evolve over time with leniency applicants, it became obvious to me that some leniency applicants, not all, would think there could be a posture that is different than full-blown cooperation. And that's what I think we're making sure we're getting the full benefit of cooperation on our side. And I think that's why Heddle says, get us the raw evidence. We understand you want to make sure we understand your view of it, and that is very important, and that will happen. But the most important thing is we should have access to your witnesses, we should have access to your documents and other materials, and that's really what the expectation is. And I will tell you, I have left meetings thinking, oh, there's something else going on, because I feel like I'm not getting the full picture. And that's weird, because you're saying you're cooperating, and yet I don't think I'm getting the full picture. So why is that? Then I guess, oh, there's a civil case. Oh, they have to, And so I feel like all that has to be resolved on the leniency applicant side. So when you're coming to us, you're coming to us in a genuine mode. And this is just across the board generalizations. Obviously, everyone knows how to do this work, but that is just my gut reaction to what, where we're trying to move to, so that the interactions are always genuine versus some of the posturing that we see. I mean, I'm sure I'm not saying it clearly, but I think I'm hopefully getting my point across.
I think we're getting the message, and in case anyone didn't get that, I think Carol has a spidey sense, so watch out for that.
You don't want it trained on you, I can tell you that.
Well, most of our, I think it's fair. I think what, Carol and I have talked about this, but, our prosecutors are experienced. They know what they're doing. Like, they can sense when the person sitting across the table from them is either holding back or saying things that are inconsistent with documents or what have you. And so, they're going to push back on that, because our expectation is, complete cooperation is truthful cooperation, right? And if you're holding back, that's just not going to cut it. Doesn't happen in every case, and I think a lot of the applicants understand their obligations, because they realize what the significant benefits are for the company, and if the individuals are covered, what it means to have committed a crime but not be prosecuted for it. But yeah, I mean, we call it a spidey sense, but yeah, there's when you're not getting the truth, and that is our expectation. for anybody who sits across the table from us.
Yeah, and the last thing I'll say, because I'm from New York, I'm a New Yorker at heart, I was trained in New York, so the first gut reaction of a New Yorker is see ya, so, if we're in, and get out of there as fast as you can. So, just know that, this is what we're trying to instill in our whole body of antitrust lawyers, like to say, all right, we're not going to have a meeting of the minds. Let's walk away. So that's important, because that matters to us that we're engaged in, and again, I know it's the exception, it's not the rule, but we just want to make sure we're getting that message out.
I have a few follow-up questions on this whole conversation, but I want to leave those for a minute and turn to Doha to bring the civil litigation, in particular merger litigation, into the conversation. First of all, Doha, what is different about the litigation program under your boss, Cantor? And one of the things we see is you've already got a very robust docket of merger litigations out there. I think you said starting with the sugar case, kicking off in a couple of weeks. Should we be thinking that you're full for now and there aren't going to be any new cases for a while you digest those? Or is there something different in store for us?
I suspect you're going to see a lot more litigation from the Antitrust Division. And to your question about what's different, I think there are a few things that are different. So the first is that you're likely to see the Antitrust Division reject risky settlements more often. So AAG Cantor gave a preview of this and talked about it at a speech to the New York State Bar Association a couple of months ago. And so essentially the division's position is that we are not inclined to take settlements. Settlements suggest like a compromise, right? We are in the business of considering remedies. And so remedies fully address the competition that is lost as a result of a merger. And so baked into that framework are a few preferences. The first is for structural relief over behavioral relief. We've heard that for many years, and that's a theme that has transcended administrations, right? It means that you'll have a single buyer with sufficient firepower to make good use of the assets going forward. And it also means fewer entanglements, and that might mean R&D entanglements, lengthy transition services agreements, lengthy non-solicitation clauses of employees. And the reasons underlying that are if it takes that many provisions to make a go of the business, it suggests there's something wrong with the remedy, and it forces the Antitrust Division to be in the posture of a regulator, which we don't like to do. And we do see ourselves as law enforcers, and so clean remedies are always going to be the preference. And this is really consistent with a growing body of literature that suggests a lot of settlements have failed, including purportedly structural ones. And we also observe real-world ways that prior settlements have failed. So we had a listening session just last week with the FTC where we heard from a New England dairy farmer about a failed remedy that the division accepted in 2017. And so part of our job is not to be defensive and defend prior actions, right? Where we have evidence that what we're doing is not working, it is incumbent upon us to change things. The second thing I think the bar is likely to see and the public is likely to see is an emphasis on the tend toward monopoly prong of Section 7. So if you've read the United Health Group change complaint, you see plenty of that. The second thing you're likely to see is where the facts and the law are available, we are likely to proceed under Section 2 in our merger enforcement. And so if you read the Versatech Crane Composites complaint, you saw that we charged under both Section 7 and Section 2. The other thing is that we're going to seek faster access to courts. And we'll have some opportunity to talk about amicus filings and real-time antitrust enforcement, but even in our merger cases, we're going to seek faster access to courts. And so I'm thinking of a recent case where there was a recent matter where there was a lengthy and protracted merger review process, and that was in part because the parties chose a course of regulatory arbitrage. Right, they put one jurisdiction ahead of the DOJ's investigation, and that did not work out well. And what we saw with our staff was that the protracted posture of the merger review was already having an effect on incentives to compete, and it was creating uncertainty in the market. And so we actually authorized the filing of a complaint and were prepared to file before the parties had certified substantial compliance with the second request. And when confronted with that information, the parties actually abandoned rather than face the lawsuit. And so this is an ambitious agenda. We know that, and we're spending a lot of time and resources making sure that the Antitrust Division has the capacity to litigate at 4 and 5 and 6 and 7 times our current docket, right? And that starts with bringing in 2 litigation DAGs, which I haven't been doing it as long as some, but I'm not aware of an AAG in recent memory who's had 2 litigation DAGs. And I think they're going to talk a bit about a litigation program that they're going to build out and make sure, again, that the Antitrust Division has the capacity to litigate at a much bigger docket.
I think that's actually the first time I've heard the DOJ say that you're prepared to file a complaint before we've even certified.
Oh, I'd love to talk about that more.
Yeah.
So,
And did you have a complaint ready to go? I'm
yes,
just curious.
Yes,
Yeah.
absolutely. So the complaint was authorized and ready to file. And look, the bottom line is there are some problems that you can see from outer space, and we don't need to wait, a year, 2 years to know where the problems lie, and where that is the case, we have to be prepared to go to court because the market is being harmed in real time.
That's really interesting. So guys, remember, they don't have to get 5 votes of a full commission bench to authorize a complaint here, something that I'm going to be thinking about myself. So we also were talking in our prep session about the broader range of tools that you have been identifying, not just within your core competence, but throughout the legislative landscape of institutions and legislation that has real substantive antitrust enforcement legs. Can you tell us about these new tools, or maybe old tools that you are dusting off, and how they're going to affect your litigation and investigations?
Sure, so I can kick this off and open it up to others who might want to chime in. So over the last several months, the division has set out to better understand and utilize the full range of statutory authorities that Congress has promulgated. And some of those statutes, they really dot the United States Code and the CFR, and some of those statutes actually contemplate direct enforcement by the Attorney General of the United States. And as many of you know, the Antitrust Division has a delegation of authority from the AG. And so we are seeking to better understand what those authorities are. And so one example is the Packers and Stockyards Act. That has an unfair methods provision and a framework for referring matters to the United States Department of Justice. And so the Antitrust Division hasn't really made prior use of this authority. But we recently announced an expanded partnership, and in January launched a joint complaint inbox that and then we also issued a statement pointing out that, as necessary, the USDA can refer matters to us for Packers and Stockyards Act enforcement. Similarly, the Federal Maritime Commission has authority under the Shipping Act for a competition cause of action. Again, this is an authority that's been rarely used, but the Attorney General recently announced that in partnership with the FMC, we, the Antitrust Division, would act as the law firm for the Federal Maritime Commission. And so there's a range of others. I suspect that over the coming year, we will likely surface more of these authorities. And I will just say for now that we are actively working with federal agencies, including some competition agencies, about the range of permissible collaboration, and that includes delegation of authorities to the United States for prosecution by the DOJ.
That all sounds really cool. So bottom line, we've got a lot more agencies, institutions, people out there who are, I expect, going to be willing partners in this litigation effort. You talked about Section 2 and using Section 2 in merger enforcement. I mean, I wish cases could be won in just regular Section 2. proceedings. It's been an area of frustration, I know, for the US antitrust enforcers for many years. So Richard, turning to you, you actually want to bring criminal cases under Section 2 when it's been really tough to win civilly. Tell us more about that. And I'd love all of you to speak to how can we get Section 2 monopolization to be something that isn't just about, someone who's owning a ski jump or, living in Aspen. How do we get Section 2 to
It's
So
not a
be
bad
more
life
applicable.
in Aspen. It's not a bad life in Aspen.
So I just have to jump in and correct a premise. So I think the problem is not that the agencies haven't won Section 2 cases. It's actually that we haven't brought Section 2 cases. And where we have brought them, we have won. The problem is the last time we did it was Microsoft, right? And so we have a live case right now. There's United States versus Google, the search case. The FTC is working on their Facebook case. And I suspect that in the civil landscape, you will see more conduct cases, including monopolization cases. So go ahead, Richard.
Yeah, this is obviously something that we discussed a little bit a few weeks ago, but jumping off on what I think we said there, the criminal Section 2, I mean, it's been a criminal statute for 130 years. It's been on the books. Congress made it a felony along with Section 1 in the 70s, and every time they reauthorize it, I think most recently in 2004, they reauthorized both Section 1 and Section 2. So that's not new. And if you look back and sort of the long arc of the division's history, you will see a number of Section 2 criminal cases. There's plenty of case law out there on it. And so, in terms of, how we do this moving forward, we're going to be guided by the facts and the law. That's what we do, right? And, I think, I would encourage everyone to take a hard look at what's on the books, because as we brought those Section 2 cases over the years, there's case law out there, and the courts issued opinions supporting the division's efforts. So, I think we're going to be guided by the facts in front of us and the law. And if we think it's appropriate, as I said, to bring charges for Section 2, then we'll do it.
Do you see a hardcore set of offences developing in Section 2 like we've seen in Section 1? And by the way, I feel like hardcore is, not necessarily as hardcore as it used to be. First of all, we've all given up smoking, and so there aren't necessarily smoking guns. So the hardcore is getting a little softer core on Section 1. Is the same applicable in Section 2?
So I'm not, I appreciate the question, but I'm not, and I understand that, it's been a while since the division has brought criminal Section 2 cases, but I'm not going to get into hypotheticals or kind of, speculate, because that's really not what we should be doing as prosecutors, right? We should follow the facts and the law as we find it. But I think, we couldn't be clearer on the fact that this is something we are looking at. So I would encourage this group, as you're thinking about, for example, your compliance programs, to make sure you're covering the waterfront, because, we certainly wouldn't be saying this if it wasn't our intention to move this forward.
Exciting times. So I think we saw this under the prior administration, a more expanded policy of going into other cases, private cases, and trying to move the law along, even when it wasn't your own investigation or proceeding. I detect there's been even more emphasis on that under AAG Cantor, statements of interest being filed in cases involving private non-solicit disputes, for instance. I'm sure those anesthesiologists were thrilled to see Jonathan Cantor come in and support them. Tell us more about this program and how is this advancing the evolution of the law and the education of judges that you think needs to happen?
Sure. So the common law approach to antitrust means that where markets evolve, so must the law. And so the antitrust division it is uniquely suited to have a positive and affirmative impact on the evolution of the law. And that means that we are going to, just as some of our predecessors did, file amicus briefs. And so there have been a few under this administration. When Richard was the acting AAG, the division filed on behalf of the players in NCAA v. Alston. We're very proud of that brief and obviously are thrilled with the decision. Most recently, we filed in digital markets cases, right? We came in to New York v. Facebook, Epic v. Apple, and we've also filed a slew of labor market briefs, including in an NLRB proceeding and in a state court proceeding involving anesthesiologists. Something like 2/3 of all of the full-time anesthesiologists in northern Nevada were tied up by a non-compete, and the division had something to say about it because we care about worker mobility. And so we see our role, again, consistent with the prior administration, as helping educate courts about the application of the antitrust laws and the realities of today's markets.
So do we have the resources to handle all of this, or are you two going to be staying up all night, every night, to make sure these ambitious policy agendas get translated into victories in court, number one? Number two, are you prepared for losses? I remember, various leaders in the past of the antitrust division have said, we've got to, break a few glasses and we've got to spill some water and we've got to maybe not always win, but we've got to try.
You got the right crowd on this side.
You do.
And that side. Right.
You do. Well, so let's put some meat on the bones of what this really looks like, right? I think probably everyone in this room knows that we have more cases in litigation than any time in any recent memory. And so what that functionally means is right now we have 6 active civil litigations, including Google, American Airlines, Penguin, Random House, U.S. Sugar, Versatech, as well as United Health Change. So that's way more than recent memory. But then in addition to that, there are 21 ongoing criminal litigations, including 2 trials that just started across the country this week. Those 21 indictments cover 42 different individual accountability cases, to include 9 involving CEOs and presidents of companies. That's significant. We also ended fiscal year 2021 with 146 pending grand jury investigations, which is the most number of grand jury investigations, as I understand it, in more than 30 years. And what these numbers, just as a backdrop to what Carol and I are going to be doing, in these roles, really show is that this is an administration, and under AAG Cantor's leadership, we're going to be vigorously pursuing both criminal antitrust violations to protect consumers and workers and businesses, but we're also going to be equally aggressive in the civil space as well, in many of the ways that Doha previously talked about in terms of rejecting risky settlements. And so, just to provide a little bit of backdrop on that in terms of how do we get to these litigation numbers and sort of to the trajectory and the velocity of litigation that we're hoping to have in the future, we take a step back to say, the antitrust division has an extremely talented staff that has a history of building incredible investigations. And we can't have good litigations without great investigations, and we'll continue to do that. But the thing that's going to be changing a little bit, or adding or supplementing perhaps, is that we're going to be adding to the overall trial and litigation capabilities to meet this demand so that we can litigate on all fronts at all times. And so what that will mean is that we're institutionalizing shared resources to support trial teams like we have right now all over the country that are starting trials contemporaneously and concurrently. But it also means that we're not going to be looking at cost as a gating factor to making our enforcement decisions. So earlier I talked about cooperation in the context of opportunity cost, but this is a place where opportunity cost isn't going to be making that decision. We are excited to have the resources and are expecting additional resources to be able to meet this demand. And so again, to put a little bit more context around that, you should know that the president's fiscal year 2023 budget includes a request for the division that's an increase of over $80 million, which we intend to deploy really carefully, thoughtfully, and strategically to meet this growing demand for the velocity of our litigation. And, that amount of money, again, is particularly coming from the U.S. Attorney's Office front, seems like an incredible amount of money. It's like, what is the value proposition there? But here, I think that it's important to note that antitrust division and antitrust enforcement investments of the sort that we're talking about and on the scale that we're talking about is a great value proposition. And I'm sure that all of you know that, not only is that value proposition captured by the preservation of competition and the gains therein and the market immediately, as Doha said, some of these deals are bad deals from outer space, and we know that, and now we can move more quickly and effectively. But in addition to that, we generate significant criminal and other fines and penalties and settlements and whatnot that allows us to capture that investment. And so I just wanted to share that I thought this was an interesting fact that over the last 10 fiscal years, the Antitrust Division deposited more than $8.7 billion in criminal antitrust fines and penalties to the Crime Victims Fund. That's real money. And that represents just the antitrust contribution is more than 42% of the $20.8 billion that's been deposited overall in that scope. And so we're thinking about, we need additional resources, and Carol's going to flesh out some of what we're going to do with those additional resources, but this is critical at this point to be able to capture this increased amount of space that we want to cover, the waterfront that we want to cover, to be able to litigate everywhere on all the issues at all the time. So Carol, how are we going to do that?
I don't have a plan. No, I think we know who the substance is on the panel and who's here for, the entertainment. So what we're doing, it's multiple fronts. Importantly, and maybe even most importantly, we have to put current trial attorneys in the best position to pursue their cases. And we are doing that. One of the things we're doing is we're trying to find seasoned folks within our ranks to spread the wealth and work either on teams directly, mentor teams. And so we are, within our own ranks, we are putting ourselves in the best position to be ready for this build-up that's been rightfully planned. The other thing we're doing, put the fishing rod out there, we're hiring. So, and we're hiring on two fronts. We're hiring trial attorneys, and we're also hiring seasoned litigators who want to jump in and help mentor the younger attorneys, or actually just outright come and help try tough cases. And what we're trying to do is build a team so that any attorney in any section will feel absolutely empowered to go, not just try a case, go try a tough case, because we're bringing tough cases, and we have to bring tough cases. It is our responsibility to bring those tough cases, and we're bringing them. And we have got to put every single trial attorney in the best position to do that, and that's what we're doing. And so, it's a process. We've already started it. We've hired folks already. We're continuing to hire people, but I will tell you, it's almost an easy time to be recruiting in antitrust, because I think people are feeling what's happening and they want to be a part of it. And so I really do feel like we're at a stage where we're going to be able to do this, because we have people within the ranks, and we are going to find folks who want to come join. So we're on our way, and it's happening. Look at all the attorneys you see right now, and who are able to try tough cases, ready to do it, doing it as we speak. It's that's what we're doing.
I wanted to go back to mergers, and don't worry, folks, we will ask about the new merger guidelines. I'm not promising that we're going to get chapter and verse on what they will say today. But before we get to your thinking on the merger guidelines, Doha, just regular run-of-the-mill merger investigations. There are so many more mergers being notified to you guys these days. I think we're still at historically high levels of activity. And we also, this is not necessarily my perception, but I think there is a perception out there among some in the bar that, the current administration thinks many more mergers are just presumptively bad than maybe prior administrations. So why should we come in proactively and tell you about our transaction if it's problematic, as opposed to the, what we call colloquially file and pray strategy?
I think it's actually pay and pray. So, look, I think that the decision about whether to come in, as always, rests with counsel, and sometimes it's not that you get a thumbs up or a thumbs down, but maybe you narrow the range of issues that could be potentially problematic. Look, I don't think our approach to mergers has changed. What I think has changed is the sheer volume of merger filings, as you noted, and, anecdotally, it does seem like they are more provocative, right? Like, we are seeing more 3-2s and 4-3s, and every single merger we learn about, the question is fundamentally, what is the competition at stake in this merger? And so that's how we conduct our reviews. And in my opinion, I think nothing really has changed in terms of the way we investigate mergers.
So do you expect to see more second requests, voluntary access letters, higher proportion of transactions being investigated up front?
I think it depends on the mergers that are notified, right? I mean, your question is about second requests, and we're in a posture where we have to be reactive, right? And so if there are mergers that come in and we have questions, then we're likely to pick up the phone and engage counsel and maybe issue more voluntary access letters.
So what about the merger guidelines? Traditionally, they've been a great resource to courts to see not only how you do these things in practice, but for example, looking at presumptions and Herfindahl's helps them to understand, is there a structural case against this transaction under Section 7? Do you anticipate that you're going to be using more use of presumptions? Are you going to consolidate the horizontal and vertical merger guidelines? Because we're really talking about mergers here, many of which have aspects of both. Any flavor of what we should expect?
So there's a lot of questions in there. So I'll take them in pieces. So
Well,
look,
I should have objected on your behalf.
Yes, you should have. Yes.
as the Attorney General said earlier this year, we have seen a tremendous amount of consolidation in the U.S. economy, and we know that unlawful mergers, failed remedies, and sometimes partial remedies can be drivers of that consolidation. And so as we think about this guidelines process, one of the most important things that we can do is create merger guidelines that can be picked up, read, and understood by anyone. And so our job really is to marry technical analysis and legal analysis, as well as a practical perspective about the potential effects of mergers. And so we're hard at work reviewing our merger guidelines to ensure that they reflect modern market realities. And so I think, as many of you know, we are following the most rigorous and inclusive and hopefully transparent process that we possibly can. And so in January of this year, we issued an RFI that seeks comment from attorneys, economists, business owners, farmers, workers, and consumers about the effects of mergers and other forms of corporate consolidation. And so we extended the comment period recently. We had expected to wrap it in March, and we've extended it to April 21st. And so if you're out there thinking about submitting comments, submit them. We want to hear them. We want to hear views from a plurality of Americans, including antitrust practitioners. So far, we've gotten more than 275 public comments, and more are coming in every day. The other thing we're doing is conducting listening sessions. So most recently, we did one about food and agriculture, and the next ones are going to focus on healthcare, media and entertainment, and technology. And earlier this week, I think many of you know, we had an enforcer summit. We had some opportunity to talk about goals of the merger guidelines. And so I can't overstate the importance of this initiative. We see harms, and we need to have merger guidelines in place that capture the complexity of the U.S. economy, and that can help us prevent, in their incipiency, mergers that may tend to substantially lessen competition or tend towards monopoly. And you asked a question about whether there would be one set of guidelines or maybe a couple. I can't really say more about that. We actually issued a question in the RFI about exactly that. What I will say is there would certainly be precedent for having one set of guidelines, and in fact, the old non-horizontal merger guidelines that were withdrawn a couple of years ago were actually a subset of the horizontal merger guidelines. And I'll also say, a theme that's come up on the panel a couple of times, including with the Justice Manual updates, is accessibility, right? Access to justice means that it's not just the most educated, most elite antitrust lawyers and federal judges who have to understand these guidelines. I mean, the public has to understand them. And so query whether to understand them, you have to decide whether your merger is horizontal or vertical, right? And so when we think about promulgating new guidelines, we should probably help the reader overcome that kind of hurdle.
Yeah, I think one of the core themes you're hearing here, everyone, is accessibility and, understanding of the ordinary person of these complex laws, which frankly I think will help us and our clients in our efforts to, both defend and protect them and get transactions through and cooperate with you.
Yeah. And I think another important aspect of the guidelines project is to make sure that our guidelines are rooted in the law as Congress has promulgated the law and as has been interpreted by the Supreme Court and the federal courts of appeals. And so my sense is that prior iterations of the guidelines have actually gotten away from that. And they have had this somewhat constraining effect on the agencies. And so part of our goal is to go back and really ground the guidelines, again, in plain language, but firmly in the law as it has been promulgated and interpreted. And in my opinion, guidelines should not read in new values that are inconsistent with Congress's values when it passed the antitrust laws. And so as we think about an administrable framework, we will take into account the legal analysis, the economic theory, and again, practicality and accessibility.
Everyone needs to dust off their baby foods case, their Philadelphia National Bank, brown shoe. Okay, that's the reading list for tonight, guys, before drinks. Richard, I wanted to make sure we covered changes to the Justice Manual and how the division handles individual releases of liability in corporate resolutions. Why are you making that change? Go ahead.
Sure, and so to answer the question, I'll start by describing what the change is, which I think will go a long way toward explaining the purpose behind the change. So our prior approach, when it presumptively afforded non-prosecution protections to all current directors, officers, and employees of a company that pled guilty to an antitrust crime. There were exceptions, or what we refer to as carve-outs, and so some of you know this as the carve-in, carve-out policy. And those were only for individuals who had already been charged or who were deemed to be potential targets of the investigation. Those protections were a term of the corporate agreements itself and were negotiated as part of the corporate resolution. And prior division officials talked about this approach in speeches and statements, but it was never memorialized in the Justice Manual or other public-facing guidance. And so over the last several years, this is another practice that we've taken a hard look at. And we've considered whether it was still furthering our enforcement mission and whether it was consistent with our focus on individual accountability. And we, at the end of this process, we concluded that we needed to do two things. First, we needed to outline this policy in a single place, which is why it's now contained in the Justice Manual. And second, we needed to update our approach to reflect the realities of our investigations and best position ourselves to move forward to keep individual accountability our top priority. So going forward, there will be no presumption that individuals from a company charged with an antitrust crime will receive non-prosecution protections. Instead, we'll do the same thing that we do with Type B leniency applicants. We'll assess cooperating individuals for non-prosecution protections based on the principles of federal prosecution, which are the same principles that are applied to targets, defendants, and all department prosecutions. And as I mentioned earlier, the essential question we ask is whether a non-prosecution agreement is the only way to secure a person's cooperation and whether that cooperation is necessary to the public's interest. And that means we consider, among other things, their degree of culpability and the value and timing of their cooperation. And of course, as I said earlier, the timing, the earlier the cooperation is, the more likely it is to be valuable and non-cumulative. And we also consider, of course, the importance of the matter. And look, we understand why we had this practice before, particularly when it came to international cartel enforcement. But as I said before, our approach to enforcement needs to reflect the realities of our current practice and our ever-expanding investigative capabilities. And on that front, over the past few years, we focused on working with our law enforcement partners and fellow enforcers abroad to increase our ability to detect and prosecute antitrust crimes committed overseas and targeting American pocketbooks. And our procurement collusion strike force now has a global reach, a global arm to it, and that can be seen in some of the cases that were announced last year. We recently announced a supply chain initiative that involves working with our Five Eye partners, utilizing all of our international cooperation tools, including our information sharing MOU signed back in 2020. And I should add that we are also working closely with our colleagues at DG Comp on this particular issue as well. And then just last month, we announced the 4th extradition of a fugitive defendant on purely antitrust charges. And we've also improved our ability to proactively investigate crimes committed domestically. And as I discussed in some detail earlier, we've increased the already strong incentives to seek leniency. And as you're hearing across the board, we're litigating more than ever. So that makes it crucial that we assess cooperators on a case-by-case basis and confirm that we are, in fact, getting the benefit of the bargain. And our new approach to to individual releases and corporate agreements reflects all of these realities. And of course, the updated approach comports with a broader approach to criminal enforcement across the Department of Justice. In my view, that's important for consistency, transparency, and equal justice, which are all themes that you're hearing throughout the day. And before we move on, I just want to stress that our approach to this issue should not be seen or viewed as a referendum, any sort of referendum on our priorities. International cartels are still a top priority. In fact, that's never been more important given the issues in the global economy and supply chain. But the effectiveness of our enforcement doesn't rise and fall with the number of corporate pleas we take from foreign companies. If we let that become the barometer of success, we will certainly fail because we will be falling short at protecting competition and consumers at all levels of the economy.
Thanks, Richard. Well, we're coming up to our time. We may have time for one question if someone wants to
But
come.
could I just
Yes.
comment on what Richard just said?
Yes.
And I know you're all hearing, and I'll take 2 seconds so people can ask questions. You're all hearing about, engaging with DOJ. I think after hearing what Richard's saying, it becomes even more important for folks to engage with us early. And the idea that that some may be waiting for an invitation. Not that anyone here is, I'm being silly, but you got to be thinking, oh, I got to engage, I got to show up, I got to let DOJ know what we're thinking, and so I'm encouraging that even more so now because these conversations have become even more important. But you know best what timing works for you and your clients, and so. We're willing to hear you out, so, come on in and let us know. I will tell you, I'm a team person, and I don't know what titles I wind up with, but I always think I'm really like a team type person. Going to the team first, I will tell you, makes sense for many reasons, but I'll tell you the one single reason it makes sense. Most folks have their best advocates at the team level. I will tell you, after my 100 years of experience, I will tell you, when you go to a team and you convince a team of something because you have a compelling point to make, you have your best advocate at that point. So it really serves you all to do it that way. I know this is all understood, happens all the time. I just want to reinforce some very basics. But sorry, and that was more than 3 seconds.
No, that's really important to emphasize. And I've actually personally experienced that. They were a really hard team to convince, but once you did, they were great advocates, with folks at your level who aren't as in the weeds on the facts.
When it gets up high,
Yeah, and Carol, do you mind if I jump on this point too?
No,
Because I know
sure.
this is like my soapbox a little bit. But
We love Richard's
as Carol said, engage with the team. I mean, we consider arguments, whether civil, criminal, what have you, front office leadership, we consider the arguments that you all make on behalf of your clients, but there is a process for that, right? And you got to follow the process. And that means starting with a team, engaging with a team, and working through them on the way up. And if we see, and questions of, certainly on the criminal side, policy or fact or law, what have you, that merit a higher level discussion, we will take those meetings, but process is important. Process is how we instill confidence in the public in this, concept of equal access to justice, that there isn't two sets of systems. And that's part of the reason why we were so insistent on this. Like, this is really fundamental to what we do. And the public's confidence in us as the Department of Justice, the Antitrust Division, is essential for what we do. And so that's why we are, we are very, we're going to be very disciplined on this and why it's so important to us. So, sorry.
We have one question here. I wanted to give the floor to who.
Hi, Leah Nyland from Politico. You guys talked a lot about trials and upcoming litigations. I think the Justice Department had a hung jury for the second time in a case against some executives accused of chicken price fixing, and has said that it intends to have a second retrial, so a third trial. I wondered if you could talk a little bit then about the process for how you guys decide when to have.
They're not going to talk about
Yes,
that.
we can't.
But I have an alternative question. I'm sorry. I should have said at the outset they will not comment on pending cases. But another question that might interest the audience here is, to what extent are you...
And sorry.
Yes. To what extent are you going after information exchanges more now these days? And, we've all kind of gone back to our healthcare statements, and we think if we can fit within those safe harbors, we should be okay. But I noted President Biden thinks those safe harbors shouldn't be safe, and we should all be rethinking, particularly in the context of wage compensation and other information that affects employees. How should we be thinking about those kinds of information exchanges these days?
So this is in the bigger basket of civil conduct matters that are really important for this front office and for the division more broadly. And so let me say about civil conduct matters that include tacit collusion and information exchanges that we are thinking broadly about incentives to cooperate and thinking about some of our carrots and sticks. And so that means a few different things. We are thinking about the range of equitable and injunctive relief that we can pursue in our cases. Sometimes that means victim redress. Sometimes that means individual liability in our civil cases. And we're thinking about, increasing our capacity to bring rule of reason cases, right? I think the Department of Justice is uniquely situated to surface conduct that is very difficult for private litigants to pursue, and so we take our job seriously to investigate those kinds of conduct. And so that means that forms of tacit collusion and information exchanges will also be on the menu of types of civil violations that we look for.
Well, I know we have to wrap up now. I could go at least another 5 hours, but I know you all need coffee. But before we leave, Doha, if there's one message that you want everyone in this audience to appreciate in terms of your objectives and the legacy that you're creating here, what would that be?
Legacy is a big word. Gosh, I think that our goals and priorities are probably pretty well stated from this panel. Our goal was to set an enforcement posture, an agenda from the beginning, and spend a few years pursuing that posture and agenda. I think, if we can zoom out a bit and talk about this moment for antitrust, I will say that most stewards and senior leaders of agencies are responsible for what happens on their watch, and we feel that very acutely. And so we are always conscious of the fact that we are responsible for antitrust enforcement at a time when Americans are really interested in antitrust enforcement. And someone much smarter than me once said that Americans look to antitrust when they are uncertain about the future, right? And so we think about how there was the financial crisis and the uneven recovery that came after the financial crisis. And we are in the process of recovering from a massive demand-side market failure that was stemmed by the pandemic. And so Americans look to democratic institutions, including the Department of Justice, for signs that we are, applying the law equally, that there aren't two tiers of justice, that access to senior officials is not reserved for, agency alums and people who command a fee of $1,000 and $2,000 per hour, right? And so we are conscious of those things, and we will do everything we can to empower our staff to bring bold and righteous cases, consistent with the Deputy Attorney General's directive to us last year that we should bring difficult cases. And I think our enforcement and our choices will speak for themselves when we're done here.
Well, I wanted to thank everyone today for what I found to be a really interesting panel and the beginning of a conversation that I hope continues throughout this conference and beyond. Please thank our panelists today.